Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the editorial dictation without any stop. The Kerala High Court has delivered a significant interpretation surrounding preventive detention under Section 12 of the Kerala Anti-Social Activities Prevention Act 2007 and the 2014 amendment which expanded the maximum period of detention. Section 12 prior to the amendment stipulated the maximum period of detention as 6 months. With the 2014 amendment, the first detention can last a maximum period of 6 months, but the subsequent detention can be of up to 1 year. A division bench of justice has now clarified that if a preventive detention order was passed prior to the 2014 amendment, such an order will not constitute first detention. In other words, detention order passed prior to 31/12/2014 cannot be taken into account for passing a subsequent detention order for a maximum period of 1 year. The bench reasoned that detention order is in the nature of depriving liberty of a person and therefore statutory provision will have to be construed strictly in that sense. Section 12 of the KAAPA would operate only prospectively in regard to the period of detention. In the sense, the first detention order must have been after 31/12/2014. In the case at hand, the detainee was detained in May last year. The earlier detention order against the detainee was in the year 2009. That cannot be taken into account for imposing maximum 1 year detention after 31/12/2014. There is no embargo under the law to detain such persons who was detained prior to 31/12/2014. In the facts and circumstances of the case, court also noted that the live link between the last prejudicial activity and the detention order had snapped. As such, the detention order was set aside with the petitioner subsequently released. Counsel for the petitioner. The Kerala High Court on Wednesday laid down that a person who did not sign a compromise which led to passing of a compromise decree but subsequently acted upon the same could not thereafter avoid the decree merely on the ground that she had not put her signature on it. In law, nobody is allowed to approbate or reprobate. To put it differently, a person who enjoys the benefit of a compromise he did not sign after filing an affidavit acting upon the same and obtained the money in terms of the compromise cannot deviate from the said compromise on the ground that he or she did not sign the same after acting upon the same. The plaintiff had instituted the suit for fixation of boundary, recovery of possession, and consequential injunction.